A mediation brief is really critical when you're providing that to a mediator and to opposing counsel in a court-connected mediation. As I always say to lawyers, your written advocacy represents half of your advocacy. In other words, if you're providing a brief to the court, you're halfway home, or perhaps more than halfway home, if you provided an excellent brief. Same applies for mediation. You're doing some advocacy work. However, the tone you strike can't be overly gladiatorial, if you will, or overly aggressive. The brief should be well articulated. It shouldn't be too long. My rule of thumb is not more than 10 pages. It should contain all the relevant documents. If you have expert reports, for example, in a personal injury case, put them in the brief. If you have an actuarial report to determine an income loss, for example, put it in the brief. I always like to see a conciliatory tone too. If you have admissions that you need to make, put them in the brief. The brief is what we call without prejudice, which means you can't be disadvantaged by what you say in the brief. It's a completely confidential document. So if there are admissions, concessions, put them in the brief. And the last thing that I like to see is whether there are previous offers. Lawyers typically don't like to do that, but as a mediator, I like to see that in the brief so I know where they left off in a prior negotiation.